And welcome everyone. Thank you very much for attending this webinar. We've got the four of us today, and we're going to talk about the revolution that's come our way, now nearly a month old, in relation to witness statements. So you have Emily Saunderson of Quadrant Chambers, Joe England, Simon Oakes, and myself, John Kimbell. And we want to make this session, this webinar, as interactive as possible. So please, if you have questions as you go along, feel free. In fact, we'd strongly encourage you to use the question and answer function. And we'll try and pick up as many questions as we can as we go along. And so I'm going to kick off with just a very short, no more than 5 minutes background as to what this is all about. And then we're going to open it up, and Emily Saunderson is going to talk about the important parts of the PD itself. Then we're going to have Simon Oakes talk about the statement of best practice, and then Joe is going to talk about another perspective on this, which is the international arbitration perspective, and he'll explain how they have approached it. So what is this revolution all about? Well, in short, it is that the judges have got fed up, the business and property court judges at least, got fed up with overlong, over-lawyered witness statements. And the aim of this practice direction, and when you're looking at the individual details, it's always, and trying to guess how the court's going to approach this, it's best just to keep in mind what is the overall aim. So what is the aim of the exercise? What is it that this whole new practice direction is targeting? Well, the answer is this, really, in three short terms. One is that witness statements are supposed to be, from now on, much shorter. And that isn't just 10% shorter or 50% shorter, but much, much shorter. And the way to get that is the second point, which is that they're supposed to be much more selective. And in particular, they are only supposed to address the points that you don't have documentary evidence to prove. So it's really shifting around from the witness being all evidence of the witness being the main way of proving facts, to documents being the main way of proving facts, and you only use a witness to fill in the bits where you really don't have any document to prove the fact. So second thing is much more selective. And the third thing is there are going to be, and the courts will force them to be, much more transparent. And that is a real change, because the idea is that witness statements will now, or ought to reveal, if they're properly done, how well, first of all, where they were taken, the circumstances in which they were taken, how well the witness actually remembered any of the facts which he or she is speaking in the witness statement, and crucially, where memory has been refreshed by reference to documents, those documents must individually be identified in the witness statement and listed at the end of it. So those are the three big changes: much shorter, much more selective, and more transparent. And at the moment, the rules only apply in the business and property courts. The new rules don't apply in the ordinary Queen's Bench division, and they don't apply in the county courts. And as to whether James Healy Pratt has asked whether it will be extended to all divisions of the High Court, it might be. Certainly, one thing I can say about this is it's not like the disclosure pilot. This is for real and forever. This is not a sort of suck it and see, and if it doesn't work out, we can go back and rewrite it. This practice direction, PD 57 AC, is permanent. So unless there's a complete disaster, the chances are that it will, in pretty short course, be extended to all the divisions. It doesn't yet apply for all of you Admiralty lawyers out there, Elliot Bishop being one of them. It doesn't yet apply in the Admiralty Court, but it will do from the 1st of October. And after that, we'll have to wait and see. Right. One other thing to say about the background to it is that this is a change which is not driven by saving costs. That's not the agenda. The agenda behind this is the judges and the judges wanting to get the best evidence that they can. So the overall, it's not expected to, it will shift work around. So there'll be, in some ways, less work done in doing the 57 redrafts of the long witness statements, but there'll be other work that will replace it. So it's probably going to be cost neutral. But the main thing to bear in mind is that this isn't about saving money. It's about the judges being concerned that they were being presented with very long witness statements, sometimes 50, 100, 150 pages, which did not represent the genuine recollection of the witnesses, and it was all basically a commentary on documents. So that's all I'm planning to say by way of an introduction. So I will hand over to Emily.
Thank you, John. I should say John was on the working group responsible for this rule change. So if you've got any particularly difficult questions, don't hesitate to direct them at John. So the first thing you need to know about this practice direction, it's practice direction 57AC, and it's very brief. It only runs to 4 pages. There are 5 paragraphs, so there's no excuse for not going through it. It's very quick to get through. It only concerns witness statements for trial, as John said, in the business and property courts. So it's Chancery Division and all parts of the Chancery Division, Commercial Court, TCC, not the straight QB, as John said, and not the county courts. John's already mentioned it doesn't apply to Admiralty claims. There's a specific practice note about Admiralty claims, which is where it says it's likely to come in on the 1st of October this year. And there are a number of exceptions for claims under specific statutory provisions where this doesn't apply. So do check the practice direction. They're pretty niche. It's things like all sorts of applications in the under the Insolvency Act. The practice direction came into effect on the 6th of April this year, so it applies to statements signed on or after the 6th of April. And it doesn't apply to affidavits, and it doesn't apply for witness statements other than trial witness statements. So if you're producing a witness statement in support of an application, this practice statement doesn't apply to that. Now, paragraph 2 of the practice direction sets out that the purpose of a trial witness statement is to set out in writing the evidence that a witness would give if they were taken through examination in chief orally. I'm not sure that's particularly helpful in terms of practice, but that's what the practice direction says. It focuses very much on if you were doing examination in chief, what evidence could you elicit from the witness? Now, the crucial part of the practice direction is probably paragraph 3, because this is where all the rules really are. And firstly, it says that a trial witness statement of fact must only contain evidence as to matters of fact that need to be proved at trial by witness evidence by reference to one or more of the factual issues in dispute. So there are 2 parts to that. Firstly, you need to be sure that the evidence that you're asking the witness to give is evidence that is necessary to prove by witness evidence. So if you can prove it by looking at the documents, it shouldn't be in a witness statement. Secondly, the evidence has to be by reference to the issues of fact to be determined in the case. So obviously you're going to look at the pleadings, but the list of issues is going to be quite important when you come to work out what evidence you need from a witness and what you can prove on the documents. Again, paragraph 3 sets out that the witness statement should only contain evidence in respect of matters the witness could be asked if they were taken orally through examination in chief. The statement has to only set out matters of fact of which that witness has got personal knowledge that are relevant to the case. So you can't ask the witness to comment, for example, on documents that they hadn't seen at the time or they didn't produce at the time, unless for some reason that's important to the issues that have to be determined. Practice direction paragraph 3 also says the statement has to identify by list the documents that the witness has referred to. So you don't put together a long exhibit, which I think was already the case in the commercial court. You just put together a list of documents. The list also has to include documents that the witness has been referred to for the purposes of producing their statement. And nothing in terms of putting that list together affects privilege that may attach to those documents. The usual rules about the statement being in the witness's own words and language apply, and the usual rules about if the witness is giving evidence as to information and belief, you need to state the source and grounds. Those rules all apply, and they're set out specifically in the practice direction. And finally, the witness statement has got to be produced in compliance with this statement of best practice, which is a new set of guidelines, and Simon's going to talk about those shortly. There's a longer statement of truth that's set out in paragraph 4 of the practice direction, and the wording is expressly set out in that paragraph. It includes that the witness understands that it's not their job to argue the case or to take the court through the documents in the case. And that's to get around or to address the problem that witnesses would be saying things like, and then I sent this email and then I got that reply. That's not what you're supposed to do under this new practice direction. The new statement of truth also requires the witness to say that where they've given evidence, they've said how well they remember those particular facts and matters, and if they've been referred to documents to refresh their memory, how that's happened and when that's happened. And under paragraph 4 of the practice direction, there's also this new requirement that the witness statement's got to be endorsed by a certificate of compliance, which is signed by the relevant legal representative. Now, the relevant legal representative is a defined term in the practice direction, and it means a person authorized to conduct litigation who's got responsibility for ensuring that the purpose and content of the trial witness statement and proper practice have been explained to the witness and that they've been complied with. Now, it doesn't say whether this person in the practice direction is a partner or an associate. That's a judgment call for the firm and the lawyers responsible for putting the witness statement together. But it obviously has to be somebody who's familiar with the way in which the witness statement's been compiled. And finally, the last paragraph, paragraph 5, addresses the sanctions for failing to comply with the practice direction. And paragraph 5 doesn't exclude any sanctions. The whole range are available to the court. It just gives some examples. And the court might refuse to give permission to rely on the statement or strike out certain parts of it. It might order that the statement's redrafted. It may make adverse costs orders in respect of the statement or parts of it, or it might order that a witness gives some of their evidence orally in chief. There's also an anti-avoidance provision in paragraph 5, which basically says that you can't, as a solicitor's firm, come off the record just before the statement's signed so that you avoid doing this certificate of compliance and then go back on the record again. The court can strike out a witness statement if it looks like that's what's happened. I'm not sure who drafted this practice direction, but they obviously come across solicitors who are far more sneaky than my instructing solicitors. But I'm quite impressed that anyone thought of that. Perhaps I lack imagination on that score. So I'm going to hand over to Simon, who's going to talk about the new statement of best practice. Over to you, Simon.
Thanks, Emily, and hello, everybody. So yes, as Emily says, one of the key things that solicitors have to do is sign the certificate of compliance that says that the statement of best practice has been complied with. So what is that statement of best practice? Well, it's in an appendix to the practice direction. And I think in broad terms, it can be divided into two. There's a process that has to be followed, and then there are some rules about what the witness, the form of the witness statement has to take. So we'll take it in those two sections. So looking first at the process, as Emily explained, paragraph 3.1 of the practice direction says that a statement must only contain evidence as to the matters of fact that need to be proved at trial by the evidence of witnesses. And that's picked up and fleshed out in paragraph 2.2 of the best practice statement. Needs to be proved is judged by reference to the pleadings, and evidence is not needed if it adds nothing to the disclosed documents or common ground. So in other words, a witness statement should no longer be used to narrate the story that emerges from the documents. It's one of the purposes that we've all used witness statements for a very long time. A witness statement is only for those things that can only be proved by oral evidence, and that is a big change. And that's emphasized by the text of paragraph 2.2, which says, amongst other things, in trials in the business and property courts, often many matters of fact do not require witness evidence, either because they're common ground or because witness testimony adds nothing of substance to the disclosed documents, and we've all been there. So in terms of the process, the statement should be based on interview. This is set out in paragraph 3.11. Statement should be based on an interview recorded as fully and accurately as possible in a durable form. We'll come on to this in a bit more detail later in the talk. If the statement is not based on an interview, then that needs to be stated at the beginning of the statement, and the process that has been used should be described. And if you are conducting an interview, that interview needs to be based on open rather than leading questions. And there's a definition in the statement of best practice of a leading question, although I think we probably all know what that is. Still on the process, the lawyers must avoid any practice that might alter or influence the recollection of the witness, apart from memory refreshing. There's a helpful paragraph that explains that memory is reasonably easily affected, is vulnerable to a range of influences. Paragraph 1.3, it's a fluid and malleable state. And so we are trying not to affect that by the statement of taking witness evidence. Still on the process, the lawyers can still draft the witness statement, but the content has to be based on and not go beyond the interview record. It can still include placeholders for witnesses to fill in bits of information after you've taken them through the interview. But those placeholder questions must be open questions for witnesses to answer in their own words. We've all seen witness statements where we've drafted things in saying words to the effect of, I understand this to be your evidence based on what you've told me so far. Is this correct? Well, that's not permissible anymore. It is not acceptable to propose content for approval, amendment, or rejection. That's at paragraph 3.13. And you can refresh a witness's memory from documents. We're going to talk more about memory refreshing as we go on. But a witness is only permitted, this is in paragraph 2.6, to refresh their memory from documents if the witness created or saw the document while the facts evidenced by or referred to in the document was still fresh in their mind. The final bit of process, and I've been picking out, I should say, I've been picking out some of the key points rather than going through every single one. But the process should involve as few drafts as possible between the first proof and the final witness statement. And that's one of the key sea changes behind the new witness statement regime. No longer is it permissible to polish up the drafts behind the scenes, to refresh witnesses' memory behind the scenes, to create this gleaming edifice that appears magically from nowhere. The idea is to have much more transparency. In terms of the document itself, on important matters in dispute, the witness should state in the witness's own words how well the witness recalls matters without documents. And this is partly a question of drafting the witness statement, but it's also partly a question of practice, because one is required to state which documents have been used to refresh memory and how and when they've been used to refresh memory. This is in paragraph 3.7. And so I think that leads, as we'll come on to explain in a bit more detail, naturally to a two-stage process where, first of all, you take a witness's evidence without reference to the documents to find out how well they recall them, and then have a second stage where you show them memory refreshing documents. Any documents that have been shown to the witness must be identified in the witness statement by list, but no longer will any statements that are referred to be exhibited to a statement. They're just going to be referred to by disclosure document numbers. That's paragraph 3.4. And importantly, documents are only to be referred to in a witness statement where it's necessary to do so. The practice direction explicitly says it will generally not be necessary for a trial witness to refer to documents. And some examples of when it will be necessary to refer to documents are given in paragraph 3.4. For example, to prove or disprove the content, date, authenticity of a document, to explain that a witness understood a document in a certain way when sending or receiving it, or to confirm that a witness saw or didn't see a document at a particular time, but only if it's relevant to the issues in dispute. And the statement of best practice specifically says that particular caution needs to be exercised if you're showing a witness a document they didn't see or create while the facts evidenced in them or referred to are fresh in their mind. Finally, before I hand back over, there's to be no lengthy quoting from documents, no setting out the narrative of the case of the documents, no commentary on other witnesses' evidence, and certainly no argument. And again, this comes back to what John said, that the witness statements are now designed to be a much tighter, focused document dealing really just with what would have been examination in chief, rather than being used as a lawyer's vehicle to set out the story and tell it in the witness statements, a convenient place. That's now gone. And so that's a convenient point to hand back over to John and Emily, who are going to talk about conceptual issues.
I think first, actually, Joe's going to talk about other guidance that's available in the arbitration.
Sorry?
No problem. Thank you. At the same time as all of this, in January earlier this year, the ICC published a report called The Accuracy of Fact, Witness Memory in International Arbitration. Now, it could be said that some of the practices which the new practice direction seeks to deal with are in fact more prevalent in arbitration than they are in court. But of course, that's also due to the submissions-based nature of memorials in arbitration, as well as the strict rules of evidence not applying unless the parties agree, and the more autonomy and procedural flexibility that arbitration brings. However, the findings of the report may be useful in considering the related changes in the practice direction. It's quite a long report, but the conclusions and recommendations are summarized in section 6. Two key ones are these. The first is that science, there was a team at Warwick University who assisted with the report in the psychology department, showed that the memory of an honest witness who gives evidence actually can become unfairly and easily distorted, and therefore may not be as reliable as it should be, or as the tribunal and parties would expect. And it gives a number of examples and measures designed to reduce that distortion in the memory process. Secondly, it emphasizes that in many cases, the accuracy of a witness memory is actually irrelevant to the evidence, and therefore the concerns over distortion of memory wouldn't apply to those. But of particular interest may be the practical measures that it gives to improve the accuracy of witness memory and the related evidence. It gives a few examples. I'll pick out one or two. First, greater input from in-house counsel, who are often the first port of call when a dispute emerges. For example, making sure you take contemporaneous notes and meet the witness as soon as possible, but also ensuring that the witness doesn't discuss their evidence too much with other members of the team. That is focused on heavily in the report as being something that adversely affects the quality of memory if you discuss your recollections over the same events unduly with others. And also encouraging parties not to take, or witnesses not to take an unduly party line to the issues they're dealing with in the witness statement. It also gives some recommendations to the lawyers themselves in terms of the way that they interview witnesses. Often they're saying that it should always be done individually. They should encourage the witnesses to have video recordings of early interviews. They should also, at a very early stage, try to distinguish between events that the witness recalls firsthand and those which are based on other sources of belief and knowledge, rather than simply that being something that's added on at the end to a witness statement. It also suggests that there should be more open questions and less steering of witnesses in the taking of evidence. Of course, on the other hand, as anyone will know who's been involved in the process, often witnesses spend lots of time trying to convince you to put in lots of issues which are legally factually irrelevant to a case. So there's also a balance about keeping focused in terms of the statement and guiding them in that regard. Finally, it also says the tribunal should play a greater role. Whether the tribunal, in the absence of the strict rules of evidence applying, would adopt wholesale the practice direction is unclear, but certainly they may be influenced by some of its contents. And it suggests that that may be appropriate for them to come up with guidance at an early stage for parties. Also, it impresses on the tribunal to try to give more overt warnings to witnesses, often before they give evidence, including telling them that it is okay to say that you don't remember. And finally, also, it says tribunals should give more consideration to excluding witnesses until their evidence, until they have given evidence. That's a summary of the ICC report.
Okay, so Let's have a bit of a chat then about the practicalities and conceptual issues that are involved or that are raised by these changes. And we're getting lots of questions in, which is fantastic. We'll try and get through them all. But one of the questions I had, which somebody has actually asked in the question and answer session, and John, this is for you. You often in a case, not always, but you very often have a main witness statement for each side, and the witness statement takes you through the story. And it might be the person who's gone to the solicitor in the first place, if it's a company director or something like that, who's familiar with what's happened, and they explain the problem, and they're the key witness. So you work out what the case narrative is by reference to what this witness is telling you. And as I read the new practice direction, that is absolutely not what a witness statement is supposed to be. So how do parties get across their case narrative now?
Yeah, there are two sides to that. One is you're absolutely right that the rules have been tightened, and paragraph 3.1 of the practice direction makes it absolutely clear that a trial witness statement must contain only evidence as to matters of fact that need to be proved in relation to one or more issues of fact. So if you just ask the question, well, what about that nice 2-3 page background scene setting section that the main witness statement would normally have? On a strict application of the rules, that has to go in the bin, because background is very rarely in issue. And it's certainly very unlikely to be a pleaded issue, which the judge is going to have to decide. So it won't, wherever it goes, it's not to be in the witness statement. So Emily, you've read it correctly. That's what the judges are going to enforce. So the more difficult question is your second bit, which is, well, where do you put it then? The answer to that is as yet unknown. There was a suggestion floating around, which wasn't adopted by the working party, was that at some point before trial there ought to be a narrative, a sort of like a memorial in an arbitration, where each party could set out its narrative, drawing together the documents, the issues, and the witness evidence into one document. But that was not, agreement couldn't be reached about when that document should come in the trial process. So what are we left with? I think in practical terms, it's going to, the narrative will be in the opening. It will be in the skeleton for trial. And I suspect the truth is, and someone's already brought this up in the question answer box, is that opening statements will tend to be longer, I think, and the judges are prepared and are willing, as a price to be paid for having shorter witness statements, to have longer openings from a trial.
So we're limited at the moment in the commercial court in trial skeletons to 50 pages, aren't we? So is there any move? Are you aware of any moves to address?
No, you can't. I mean, it's a very rare case that you can't properly summarize in less than 50 pages. So they're not expecting 200 page openings, but they're just, your question is, there's almost in very many commercial cases, you do need to get your narrative across, and the judge is always looking for what's the story here, what's actually happened. So it needs to go in somewhere, and the only place that's left, frankly, under the new rules, is in the opening for trial.
Which is quite late in the process, isn't it, for you to find out?
It is, but don't forget, this is,
the other side's case.
Yeah, it's late, but you know, you can set the background for a CNC or any application in the same way in a skeleton. But don't forget, this is a set of rules which is about witness statements for trial. So where we used to spend a lot of time and paper getting the background in the witness statement, in particular in the witness statement of the lead witness, that has to be transferred elsewhere because it cannot be in the witness statement. It will be struck out.
Certainly, if we're in front of you, John, I think it will be struck out.
Probably also means that there has to be more, that one has to be a bit more careful, perhaps, in how you plead a case. That to the extent that you're going to put any spin on the narrative, in fairness, it probably needs to be in your pleading somewhere. That you can't it would be somewhat unfair if you received the other side's skeleton 2 days before the hearing and discovered the way that they were spinning the facts. You really genuinely need to address that.
Possibly, but I mean, certainly there's no intention on the to impact in any way on the rules of pleading. That the rules of pleading, if anything, the tendency is the same, which is to go shorter. And the commercial court has its a maximum page limit. You can apply to exceed it, but the tendency is plead only facts, don't plead spin and narrative. And so really the only place that you're going to get your slant across is going to be when the case is presented at the opening of the trial.
Which is slightly terrifying from my perspective. I'd much rather know if there are any issues on documents, particularly any issues of dispute, which won't necessarily be main issues in dispute on the pleadings, but you might see an email, for example, and think, oh, that obviously means such and such. It's not dealt with in their witness statements, but you see in their narrative, oh, they read it in a completely different way. Had I known that, I might have called witness evidence.
Yeah. But it's probably a good time to pick up some of the questions. Hearsay evidence, just to make it clear, there's absolutely no intention to undermine the rules on hearsay. In some ways, hearsay is your friend, because multiple hearsay in civil proceedings is admissible without any more. Anything that you want to rely on, you can refer to texts, documents. It doesn't matter if it's a report of someone who said something, something else. Multiple levels of hearsay are equally admissible, so there's no change to any of those. And similarly, in the witness statement itself, if it's necessary for you to prove an oral agreement and you heard someone say, yes, we accept the offer that you have made, that's perfectly admissible in a witness statement. There's no problem with that.
Can I ask a slightly, it's tangentially related. Doesn't this lead potentially to tactical witness calling? So, for example, if you look at the documents and you're reading through emails and you think, oh, this person is all over it, this is going to be a great witness, very clear in his emails, it's very clear on the basis of these emails what's happened. Then you meet the witness in person and they're a mess, they're unreliable, they obviously write a lot better than they speak, and you start to doubt whether what's in those emails is actually correct. You can get away without calling that witness because you just say to the court, well, it's all obviously in the emails.
Yeah.
And the other side doesn't, it's not like documents where you have to disclose the adverse document, the adverse witness. You can just get away with it. You don't have to tender that person for cross-examination. Does it affect the way in which a court is going to treat a request to draw adverse inferences because you haven't called a witness?
Yeah, that's an interesting one. I mean, but certainly the first part of your question, will there be cases now where you can very easily get away without calling the witness and you won't be met with judicial surprise? The answer is yes. In some ways, the logical extension of the changes is that there ought to be trials that take place entirely on documents. And I think what is expected, certainly what the judges expect, I think, is that for at least for medium to large size cases, once the pleadings close, one of the first things that the lawyers on both sides are expected to do is to go through the pleaded issues and say, right, which of these issues do I really need a witness to prove? Have I got a document? If I have, tick, I don't need to worry about it. And you may find, and I think this is what the judges really want to happen, is a sort of old-fashioned advice on evidence. Here are the 27 issues in the case, which you certainly will have worked out by the time you get to the CMC. How many of those can we prove by documents? If you can, you don't need the witness. And it may be that you only have 1 or 2 or 3 issues where you really need witness evidence. And so, yes, if you're in a lucky position where under the old rules you would have called a witness and he would have or she would have been a disaster, in that sense, yeah, under the new rules you may get away with this.
And I think it's
now, but as to the adverse inference, that's a very interesting one as to whether my suspicion is that there will be less reliance on adverse inferences because any party who hasn't called the witness will just say, well, I was complying with the practice direction. I don't need the witness to prove this. And so I think it will have an indirect impact. Adverse inferences won't be drawn so often.
But it presumably means that one needs to grapple with all of this very early on to get a real grip on what it is that you are going to need your witnesses for, but also how good their evidence is going to be, how good their memory is going to be even once you've refreshed their documents, because it's going to be very difficult to control that evidence in the statement. You're not going to be able to sort of draft around what a witness has said to try and make their evidence a bit better. And presumably it's going to need to be grappled with, because it's going to have a serious effect on the trial length as to how many, is this going to be just a document only trial, or is this going to be a trial where we're going to be beating the witnesses up about how much they've memory refreshed and all the rest of it? I wonder whether there's any, I suppose it'll just have to be a case of slightly suck it and see, but one would be tempted in some of the early cases to build in a bit of extra time in a case where you're going to be dealing with witness evidence, because of the possibility of having to get into all of this at trial. For example, if you're, I suppose from a time estimate basis, you have to assume that none of this is going to happen. But it would be, if you're in one of those cases, for example, where the judge decides that your witness has not complied with the statement of best practice and he wants the witness to be examined in chief, there might not be time in the time estimate for that.
Yeah, I mean, I'm sure that's right. There'll be some cases in the first year or so where things will go badly wrong, and if yes, it will potentially put a massive spanner in the works of all trial management if instead of producing the witness and saying, well, is what you say here true, that you have to then do old-fashioned examination in chief orally. But those will be rare cases, because the idea behind the practice direction is for these issues about witness statements to be sorted out before the trial. So if one party is going to say that the practice direction hasn't been complied with by the other party, they need to raise that at the very latest at the PTR. Ideally, you would raise it as soon as the witness statement is served, and then you make an application to have the witness statement struck out in whole or in part. So by the time you get to trial, the idea is that the witness statements will all comply. But let's perhaps, if we, Emily, should we move on to some quite practical points have come in, which and in particular there is this issue about what about the witness client, because the practice direction is modeled on as it were sort of distant witness. You sort of call in and say, did you see X, did you hear Y? What about when your main witness is in fact the client? And the practical answer in that situation, if you know already they're going to almost certainly give evidence as a witness, that you know that that there are going to be issues in which they will be required to give evidence orally, I think the best approach is to get an early proof from them right at the beginning, as soon as the instructions come in, as part of just getting a handle on the story. Sit down with them, get a proof, and that is your first proof. And it may be that it turns out you don't need that person, but that is it seems to me the safest way, because as I said, if you keep your eye on the ball of the three things, witness statements, shorter, more selective, and transparent, the only way you're going to guarantee transparency is if you interview that witness, even if it's the client, in a very open way, and just get down what they are telling you without reference to any documents. And then that's your starting point. You can keep that in the drawer, and when it comes to producing the full witness statement later on, that's what you start with.
We've got some questions. We've got other questions about do you have to, where a witness has given instructions, do you have to include the list of documents that they have provided you with while they're giving instructions? And my reading of is no.
Definitely not. This is all about transparency in the way in which the witness statement has been put together. It's it's very basic in a sense. It's their evidence when they go into the witness box and confirm that their witness statement is their evidence. That's what really matters. And so it's only those documents that they have used for that purpose. And also similarly, if after they signed their witness statement with their list of documents at the back, there's nothing to prevent them from preparing for trial by reading every single document in the trial bundle. There is not a requirement that you then, having got the witness statement, that you then put them in a sealed room and you don't speak to them again for the next 6 months until the trial starts. There's no suggestion of that. So they can read everything that they like. So the idea is that it's about the quality of their witness statement and their witness evidence. And that's the focus of it.
Okay. Simon and Joe, did you have questions or comments about procedure that you want to address?
You mean in terms of practical issues about drafting a witness statement for trial and that kind of thing? Yeah. Well, look, I think we'll come back to the question in detail because some of those points are really interesting. But just as a very, very broad brush thumbnail sketch of how do you prepare a witness statement for trial now?
Yeah.
Dealing just with the vanilla situation, not with the specific detail of, for instance, if your witness is the client. But I think the starting point is to get the pleadings out in front of you, the list of issues, and work out what needs to be covered in evidence generally, whether it's in contemporaneous documents or witness evidence. Then go through your contemporaneous documents and see what's left after those that still needs to be covered by witness recollection. What are the gaps in the evidence that need to be covered that can only be dealt with by witness recollection? And then, quite obviously, prepare your questions in advance of the interview really carefully. More than ever, they need to be very carefully thought through. And it's essentially examination in chief. So in certain cases, there may be some benefit, shameless plug, in involving counsel in framing some of those questions or assisting with the process. And carefully consider the contemporaneous documents that a witness needs to be shown. Explain to the witness the interview process, the rules you have to follow. Consider recording the interview instead of just taking a note. And as I mentioned before, have two stages to the process. What do you remember without reference to the documents? And then, having refreshed them, what do you remember now? As John says, it makes total sense to take the statement as early as possible to preserve memory. For some witnesses, as I mentioned, you'll be able to wait until the pleadings have closed and you've got your list of issues. For others, where their memory is necessarily going to be tainted by the process of giving instructions being involved in the case, get something early as well. And so that very much in a nutshell is a 101 of how to approach a witness statement for trial. Joe's going to talk a bit later, I think, about memory refreshing in the context of global display solutions.
I was just going to pick up on perhaps now on those two points. And one is we've already touched on one, which is who signs the dreaded certificate of compliance. And Emily helpfully took us through the definition of a legal representative. And Simon's also touched on this with the best practice, but obviously there's a decision has to be made, because obviously the person that signs it has to do so truthfully, has to be familiar with all the various requirements of the practice direction and the statement of best practice, but also has to have been somewhat involved with the actual process, which is often started or managed by more junior lawyers. But if it's to be signed by a partner, for example, they need to have had some involvement in the process in order to sign the statement. So I think I agree with what John said at the beginning about broadly the cost neutrality of this. But one area where I think will be extra cost is having someone more senior involved in the whole process of witness statements, and therefore especially if they're to sign the statement. And the second point that Simon helpfully mentioned was a case this year, although it was before the statements in question were prepared before the practice direction came into effect. The decision was made with reference to it afterwards. And I think that touches on this point about refreshing memory, where obviously one's got to be cautious in how one refreshes a witness's memory with regard to documents. But I think the way that I read the decision is called Global Display Solutions versus NCR Financial Group, decided by Mr. Justice Jacobs in the Commercial Court. And in that case, the party in effect tried to exploit the fact that it hadn't shown its witnesses or refreshed their memories too much by showing them contemporaneous documents. And the reason I say exploited is because it suited their case to argue that the financial projections made were based on rather vague variants rather than having gone through everything in detail. But I think that case shows you that you can go the other way and not refresh a witness's memory, where perhaps you should show them some of the documents. And Mr. Justice Jacobs said that in terms that there was no reason and there was provision in the practice direction for witnesses to have their memories refreshed over important documents. So they couldn't simply say it was inappropriate to refresh my memory on those key documents.
Yeah, I think, Joe, that's a very good point, and it comes back again to the transparency thing, which is the judges don't have any real objection to witnesses seeing documents. I mean, they're realistic in the commercial world. If you ask me what I was doing or what I thought about something 3 months ago, I'm going to start looking at my emails. That's not the problem. The problem has been in the past that we've presented witness statements as if witnesses have perfect minute by minute recall of events that took place 7 or 8 years ago, down to who was in the room, where they were sitting, just too incredible for words. Whereas what's now being required is just make it clear what you actually remember and what it is that where you've refreshed your memory from documents. And as long as you're clear about that. But that's probably a good time to pick up. There's a very interesting question about what you do if you refresh a witness's memory and you get an answer you don't like. Do you leave it out of the witness statement? But you still have to have the document listed in the list. Well, that is the position. If you ask a question, you get an unhelpful answer when drafting the witness statements. Yes, you still have to list that document. And I think you're right to say, whoever it is, that it'll be interesting source of potentially good cross-examination to see the documents that were referred to, but don't actually whatever they covered disappears from the witness statement. Someone else asked a question about if a judge thinks that the practice direction hasn't been complied with, can they call upon the party to produce drafts? The answer is no. That the rules don't change the law of privilege. So the drafts of the witness statements will not be produced in the proceedings.
John, can I ask, in terms of privilege and the process of actually taking the witness statement, I think as a matter of human experience, we all know that sometimes we misremember things, particularly if there's no particular reason at the time to remember it, and then you're asked about it sometime later, you think something happened, but you check your emails and see that it was something totally different. Does the witness statement now need to say, when I was initially asked about this, I thought X, I then looked at these documents, realized I had misremembered, but on seeing those documents, I do actually remember what happened, and it's Y.
Yes,
definitely. It needs to go through in that level of detail. Yes,
in principle, that is the intention. So you're being absolutely clear. What is it that you actually remembered at the time? And because sometimes the position is that you're shown a document and you say, well, that's just not how I remember it. It may well be the case that that's what happened, but that's not how I remember it. So the witness statement should set out how you remember it. That's your evidence. It's then up to the lawyers to say, well, the witness says she thinks it was X. The documents all show something else. And then it's up to the judge to say which is preferred. And applying the Guesting principles, most of the time, most judges will go with the contemporaneous documents, but not all the time.
But if it's your own witness,
yeah,
surely you're allowed to say to them, they say X, they say, this is I'm absolutely convinced, I remember it very clearly, this is what happened. And you've got a document in front of you that they've produced that shows that they're just wrong. You must be able to show that document to them, rather than waiting for them to be.
No, of course you can show it to them, and no one's asking that the witness goes into the witness box without having looked at any documents, but you just have to be clear about what your memory actually was when you were first asked about it. And what quite often happens is that having seen the document, the other memories are then triggered. So you can then say, well, when I was first asked about this, my memory was that the meeting was in early spring and what we discussed was X, Y, and Z. But I've seen a protocol produced in disclosure which says something different. But I think the protocol is correct, and I think that because I remember now X or Y. So it's just so that we're no longer engaged in this pretense that you can produce this 70-page document which purports to be what you remember and what your evidence is, but is actually 98% drafted by lawyers on the basis of documents.
There's also a question on privilege, a helpful question about how you deal with privileged documents and refer to them. Do you list them out in the statement? And my own view is that you probably do a similar thing to what you do with a disclosure list in terms of either identifying them in a very generic way.
Exactly.
Yeah. And it doesn't affect the privilege in the documents, just listing them. So
no.
Yeah.
And it is you do have to be very careful, of course. I mean, if you do show a witness a privileged document and they refer to it, of course you've waived privilege. But Joe's right that if you are not intending to waive privilege, then you list them, but generically you still claim privilege. You don't lose privilege automatically just by showing it to the witness. Just by showing it to a witness, yeah. Okay.
We've got some interesting questions about foreign lawyers' involvement in drafting witness statements. How do you deal with if you've got a witness abroad and you're liaising with foreign lawyers?
Well, yeah, that is a very interesting one, and the answer is that it's not the foreign lawyer that will be signing the certificate of compliance. It will be the English solicitor on the record. So you just have to make sure that the foreign lawyers understand the rules and comply with them.
Okay.
Somebody's asked whether it's possible, whether it's permissible to help with clumsy wording in a witness statement where the point made is not very clear. And for my part, although the rules say that the answers should be in the witness's own words as much as possible, the aim of that provision is not to require confusing language to find its way into the final version of the witness statement. I don't think there's any problem with lawyers structuring the statement in a way as to make the meaning clear, as long as the meaning isn't changed.
No, that's right. There's no problem with making things clearer. But what you can't do, and what has happened in the past, is that you can't produce a long witness statement sort of ready baked based on extensive review of the documents to say, is this right? You've got to go through the stage of just sitting the witness down and taking an old-fashioned proof of evidence by asking open questions. So that's the big change. But certainly, if you proofed them and asked open questions and you've got a proof, thereafter, when you're at the phase of turning that proof of evidence into a witness statement, there's no problem at all with correcting clumsy language. But just to pick up this point about the foreign qualified lawyer, the practice direction is quite specific about relevant legal representative, and it's someone who's authorized to conduct litigation in this country. So the answer is no, foreign qualified lawyers can't sign it unless they are a foreign qualified lawyer who happens also to be authorized to conduct litigation in this country.
Can I just, a very quick question. Sometimes you come across a witness who just uses the phrase, I can't remember, because they don't want to give evidence, they can't be bothered to help, they want to do something else. So you ask them questions and say, I can't remember, I can't remember, I can't remember. And you're supposed to be asking open questions. So for things like, say, how long was the meeting? I can't remember. You can, do you guys think permissible to say, well, come on, was it 5 minutes, an hour, 5 hours? I mean, arguably those are leading questions because you're suggesting a range of answers, but you're just trying to pin the witness down.
But that must be permissible. It's the kind of question that one has always been able to ask in examination in chief. And it seems to me, that's what we're aiming at here, is to try and replicate examination in chief, but not live in court. And so it must be permissible to do that.
Yeah, it is. I mean, you don't want to, yes, it is, because you're just simply trying to clarify and elicit some further information. But that seems to me, yeah, I would agree. You must be able to do that, because all you're doing is trying to, when you say, was it 5 minutes or 5 hours? If the witness really doesn't want to help, no matter what you do or say, they're not going to provide the evidence. But if they're anxious or nervous or whatever, then those sorts of questions are quite helpful, because you're saying to them, well, I don't need to know precisely down to the last second. I just need to know, was it a quick 5-minute meeting, or was it a long 5-hour meeting? And if most people, if they want to cooperate, will say one thing or the other, or say it was a longish meeting.
Yeah. Now, we had a couple of questions before we started, so I think we should address those as well. One was, it was about organising the witness's evidence. Often when you speak to a witness, it's quite chaotic. There's nothing wrong with the lawyer taking control of the statement and putting it in an order that's user-friendly.
No, that's expressly allowed under the rules. But one of the other questions is, which I quite like, is presumably lots of solicitors will just carry on doing it the old way and hope no one notices. What do you in practice think the other side? Sorry, what do you do in practice if you think the other side is not playing by the rules? Well, I do hope that lots of people don't carry on doing it the old way, because if they do, the sanctions are fairly draconian. And if you get to a PTR and your witness statements don't comply, then it's almost certain that they will be struck out, and then you won't have any witness evidence. You'll be told possibly you've got 2 weeks to put some further witness statements in, but it won't be a comfortable place. So I would seriously not advise, and that's why I say this isn't a pilot. This isn't a sort of, oh, let's see how we get on and see if we can move things. The judges are really serious about this, and they want things to change. And what came across in the response to the Working Party was that the overwhelming response was the old rules were never enforced properly, and people were wanting them to be enforced. And if you think the other side isn't playing by the rules, then my advice would be make the application, be upfront about it, and bring it before the court.
And John, I think you were saying in previous discussion that there may, due to these changes, have to be revisions to the commercial court guide, for example, in regard to other procedures to bring everything in line. Do you think that's likely?
Yeah, I mean, the commercial court guide is a matter of public record. It's under review, and the new version's coming out in October. So there'll be some adjustments to take account of this new practice direction.
I mean, presumably the likeliest thing that will happen is there will be a few cases where either through cunning or indolence there isn't compliance with these new rules, and there'll be a couple of really hard judgments that come down on parties quite harshly. But fairly, and produce some pretty draconian responses to make it clear to the legal world that this isn't going to be just like the practice direction with lots of Model D answers where everybody tries to muddle along as they were before. It really is a brave new world.
Yeah. And to pick up on another question, what do you do if you've got a trial which has been deferred? So you were expecting it to come in before these new rules, and it's now going to take place after them, but you haven't got your witness statement signed. It's fairly brutal. I mean, the position is quite clear. Instead of having a sort of adjustment phase, the rules just came in suddenly. So if your witness statements were not signed by the 6th of April, you have to comply with these, unless and insofar as you can make an application. I mean, there is one part of this practice direction that doesn't often get much of a mention, but which it specifically provides that you can apply in advance for a dispensation not to comply. So if you've already gone a long way to drafting your witness statements, where you've obtained a document ages ago, and it wasn't possible to sit down and take a proper note and prove the witness in the way that the practice direction says, you can explain that and get a dispensation. So there will be a phase where I expect there will be quite a lot of applications for dispensation for complying with the rules. But the underlying rule is, if you haven't got your witness statement signed, you must get as close as possible and to the rules and comply with them as many as you possibly can. And if you really can't, then apply to dispense.
Right, well, we've come up to an hour. I don't know if it's just me, that seems to have gone quite quickly, shockingly, for a seminar.
Yes, okay, yes, it is, absolutely. Well spotted, Emily. Well, I hope that it's been useful. We tried to answer as many of the questions as we could as we went along. But if we haven't been able to, don't hesitate. You've got our contact details at Quadrant. All 4 of us would be more than happy to answer any further questions if you send them in by email, I'll just pick up the phone. So thank you in particular to Emily, Joseph and Simon, and for Sarah as well, who behind the scenes organizes all of these events. I hope you've enjoyed it. Thank you very much. Bye.
Bye.
Bye.